So, you know, that I think is cause for concern, and I'm sure the Chief Executive will take that on. Again, I find it difficult to believe, looking at Councillor Biggs' question 1, officers who were party to the 2002 decisions no longer employed with the Council, and no records exist. I find it difficult to believe that no cabinet or council minutes exist on the appended documents. They must exist somewhere, and the appended reports that led cabinet and council to make their decision at the time.
Just to clarify, sorry, I was being quite precise in my response. No records exist of what evidence cabinet members based their recommendations on. But obviously we've got the copies of the reports that were considered, but as have you seen, I've got nothing in addition to what you've seen.
Okay, thank you for that. Councillor Biggs mentioned a different position. We've got to that different position as a result of changes that have been made by successive cabinets, not administrations, cabinets. Question 5, no, it wasn't Clive Hart, it was Dennis Hart, was the cabinet member at the time. But of course, between the period 2003-2009, we clearly had experts in charge, a carpet salesman, a retired army officer, and that's how we've arrived at the position we're in today. Councillor Biggs is correct in one thing. There is a document in existence. There's no decision in the offing. And I believe that Mr Patterson knows the document to which I'm referring to, and I believe that as part of our remit to find a way out of this mess, we need to look at future options, and I think we should see that document. If you want to enlarge on that, Mr Patterson.
Well, we are in a public meeting, so you'll forgive me for perhaps being circumspect in what I say. But yes, we are in a position where the officers would intend to report to Cabinet, probably to an extraordinary meeting with a set of documents, with revised documents. And if you're saying that you would like to see them here first, if that's what you're saying,
yes,
then obviously we'd have to accede to that. The only issue, of course, about that is that we would have to ask you to call an extraordinary meeting fairly quickly, because obviously the decision cycle is this, that you report to scrutiny, and if scrutiny then consider any recommendations you might make, they then get reported onto the Cabinet, and so we'll have to squeeze in, it seems to me, if you look at it, 2 meetings culminating in some recommendation to Cabinet about what they should or shouldn't do based on those documents.
I do have a couple of people still in line, so I'll keep the line we've got. I've got Councillor Driver, then Councillor Nixon, and then back to Councillor Binks.
Yeah, thank you, Chair. Not exactly a surprise. I mean, people who avidly read Thanet Watch know about the Golden Balls email, and perhaps that might well be something to do with the meetings and discussions that took place leading to the production of the latest the latest reports. But I do agree that those reports should come here, and come here as quickly as possible, because this working group certainly has a remit to have a look at the future, and we need to be able to express our views to the Cabinet. A couple of other things, say follow that, because actually it is quite a surprise. But a couple of other things. Councillor Binks talked about the cost of the cliff wall, and the answer to the cliff wall suggests that the developers put in £600,000. Well, they didn't. It was £100,000, and there was a freedom of information request, which I believe Michael Child put in quite some time ago, where it was clearly said by the council that the developers only put in £100,000 on the cliff wall. So there you have another 500,000 in that calculation gone. And I must actually congratulate Councillor Binks on her absolute honesty, because I don't think Councillor Binks was trying to make a political point about what went on. She's openly criticised her own party in relation to what went on in 2009 on more than one occasion, and I've heard her. What Councillor Binks is trying to do, and I think is absolutely right, is to provide an objective historic assessment of the decisions that were taken that have got us to here. because she's absolutely right to say that the only way we'd avoid anything like this happening again is by learning from our mistakes in the past. And certainly there were mistakes, because the Audit Commission didn't report once on this, it reported twice. There's a 2001 report, there was also a report in 2004, and even then the Audit Commission was not very happy about the way that the project had been managed politically, both parties and by officers. So the Audit Commission came, they looked, they were concerned, they suggested that things be done, they came back and looked again, some had been done, some hadn't been done, and probably one of the biggest things that hadn't been done by this council during that period was to get current market valuations on that property, and that's what the Audit Commission said, not me. So it has been managed badly, and we should learn from those lessons. And one thing that does surprise me is that Eversheds might not have the original documentation about the 2002 beauty contest where a decision was made. There must be records, and I believe they must be intact somewhere, and I believe that the Cabinet was advised by a secretive subgroup, which I think is referred to in the minutes of one of the earlier meetings that took place. And furthermore, and I'll stop soon because I've been going on a long time, there is a document in common circulation that was produced by members of the Conservative Party who went under the title of the group to improve Sandwich Bay. And one of their people who I have been in touch with is an eminent history lecturer somewhere outside of Thanet now, and members of the Conservative Party, according to this document, challenged Councillor Ezekiel and asked him some very, very serious questions about why he had approved the deals that they did, and also as well there was a direct challenge to the then head of Development Services. And that is in minutes which have been passed on to the police. That is in a document that's been circulating for a long, long time around Thanet, that even members of the Conservative group were concerned about the way that their administration was managing this. So it goes across the two parties, and I won't belabour the point anymore, but I think it was Councillor Will Scobie, when this issue first came to scrutiny some while ago, who said this deal stinks. It does, it still stinks. I think Will Scobie retracted his comment sometime after that, but this deal does stink, and I'm very concerned that someone is trying to revive that deal with a company which we know more information about now, and a company which I suspect is going to carry on taking advantage of the taxpayers of this council.
Thank you for getting my name right. That's a good start, isn't it? However, I am astonished, absolutely astonished, at the claim that there are no documents in evidence of what happened in the lead up to 2002, December 2002 full council meeting. I can say that the presentation by the developer was made and council overwhelmingly supported it. Councillor Harrison has then detailed where it went from there. But I do want to raise some very disturbing things, and it's been referred to. What's been referred to is actually in the draft cabinet for the 14th of November, item number 10, development agreement and leases. A document, as far as I'm aware, members were not privy to until they saw it, I think, on Monday. I may be wrong, it may be Tuesday, but they certainly, when they met, they had sight of it, and they are shocked that
you know, contrary to the wishes of this task and finish group, that an officer would present such a document to them and try to be brought forward on the 14th of November. I'm not going to talk about what's in that document. Sorry, on the 14th of November, I'm not going to talk about what's in that document. However, there were several options put in front of them. The leader in cabinet, I think unanimously on that evening, agreed that should not come forward at this time, because like everyone else, we're all still waiting on independent legal advice on what the actual options are.
Yes.
However, and perhaps whether the Chief Executive or Mr. Patterson would like to comment on, I understand that the Chair of Scrutiny was approached to see whether that document should come to us this evening, and it was rejected. What it's got to do with the Chair of Scrutiny is one question. It should have been yourself, Chair. Looking at your face, I don't think you know anything about it. But I want to know why the Chair of Scrutiny was approached, and can you confirm that the decision was made not to bring that in front of members this evening?
First of all, what was presented to Cabinet this week was a draft report at the pre-agenda conference relating to negotiations that had been ongoing with the developer. Your recommendation has in fact gone to the Scrutiny Committee. The Scrutiny Committee has endorsed that recommendation, just for the record. Of course, that will be reported to Cabinet at the next ordinary meeting on the 14th of November. Until then, there is no embargo on officers negotiating with developers, which we're doing under instruction. What I would say, of course, is that there is a recognition by Cabinet that if any report is to come to them with recommendations in relation to Pleasurama, Scrutiny needs to look at it. And based on that, the officers were asked to go and speak to the chairman of the Scrutiny Committee with a view not to it being brought here tonight, if I could just correct you about that, with a view to the Scrutiny Committee sitting to consider that matter. That they could then look at the report that would be proposed to Cabinet, so they could look at the report that we are proposing to put to Cabinet, and Cabinet could then take that report, probably at an extraordinary meeting, with the benefit of the views of Scrutiny. But the decision was taken by the Chairman of Scrutiny that actually, if they were unhappy with the decision that was taken by the Cabinet, in due course they could always call it in. So it was left at that point.
Chair.
Please don't indicate otherwise.
Could I move a procedural motion, Chair? I'd like to move that those documents be presented to a meeting of overview and scrutiny at the earliest possible time, the panel, and in any event before it goes to Cabinet.
I'm not, Mr. Patterson, I have to confirm, I don't know if we can even pass it. All we can do is make a suggestion. We have no binding power to say that something must go to scrutiny. I don't believe that's the case.
I think constitutionally we can see any document that is in the possession of the Cabinet, and the document is already in possession of the Cabinet, so I think we have a constitutional right to see those draft documents because the Cabinet's already seen them and we have a constitutional right to see them. So I move that we meet at the earliest possible time to see and discuss those documents, as is our constitutional right as a subgroup to do.
If I can just speak briefly before any decision is taken on that motion. It hasn't been seconded yet. What Cabinet has seen is a report. They have not seen any documents. So they have not seen documents that you haven't seen. What you need to be clear about is whether you want those documents brought here or whether you are going to make a recommendation, formally move that it be a recommendation to overview and scrutiny, that they look at that at the earliest opportunity. You can make that recommendation. You can also instead agree that they're brought here, and you can look at them and then make a recommendation to overview and scrutiny. If you do that, of course, we will have to look at, squeezing into the decision process, your decision, overview and scrutiny, then Cabinet, or else it can go to overview and scrutiny, you can look at it and go to Cabinet. That is a shorter decision span, so it really is up to you which way as a working party you want to proceed.
Hang on, Councillor Binks.
A point of information, really. It's not us that are making the decision.
It's not overview and scrutiny that make the decision, it's the Cabinet that makes the decision. And I'm very reluctant to have something passed over to me so that it looks as though we've condoned something. And I feel very much that we're being set up here, because there's a little bit too pat. Mr. Patterson coming in and having, it just feels to me as though this was already rehearsed. I see no reason, and people shaking heads doesn't really reassure me, but I see no reason for us to, we can look at papers, but I don't want to be in the position that we're making a recommendation based on something so that it looks as though we've condoned something, when it's actually Cabinet's decision, and they're the ones that have to stand or fall by it. May I, whilst I'm here, say that Councillor Driver's correct. I was not making a party political broadcast because I have made my feelings quite clear as far as decisions that were made by former Conservative administrations. I make no excuses for any decisions that were wrong. Whatever the reasons for them being wrong, they were wrong. I make no excuses for the fact that people have made decisions in both administrations at various times, and I think mostly they did it for the right intentions. My sole criticism was that two people, particularly one person, but two people who were in the Cabinet, who were in a position to make decisions, or at least participate actively in those decisions, are now reviewing what went wrong. And I don't think there are many committees where you would have people who were actively involved actually deciding on themselves and their own actions. That was my sole purpose with saying that. Not to make a party political broadcast. And but I accept that, that there was bound to be a few snide comments from Councillor Harrison because he is in the habit of making them. However, my own point is I have no problem with seeing documents that I know nothing about, although I have heard a rumour, but I know nothing about them. But I'm certainly not going to make a decision. The Cabinet, the present Cabinet, has to make that decision and stand or fall by it.
Well, Chairman, of course, you won't make a decision here, and neither will the Overview and Scrutiny Committee, but I have to say there is nothing unusual about pre-decision scrutiny, and in fact it's something that scrutiny has been arguing for a very long time, and something
You have, Councillor.
routine in terms of all our policy documents. They come to scrutiny first, and I don't for a moment presume your decision, because what you may look at you may not like, and you may indeed make recommendations the Cabinet don't like, so I don't see that this is in any sense corralling members into a decision. You know, I think if you want to look at the documents, it's our duty to bring them before you, and you will make of them what you make of them, and you'll make whatever recommendations you so choose, regardless of that, the Cabinet's feelings about that recommendation.
Okay, I'll come to Councillor Harrison in a second. Generally, this whole last 10, 15 minutes has been talk and discussion about documents and rumours and things that, it seems ludicrous really that we're having this conversation about something that actually doesn't exist or hasn't been mentioned. My own personal view is, I agree totally actually with the Chair of Scrutiny. I don't think we should come here. We can, if people would like to recommend that a scrutiny extraordinary meeting is held, or that we say we think that should happen, I think that's where it should go. I don't think our terms of reference mean they come here, and that is my personal view. Other members may disagree, but that is what I think. I personally think the Cabinet should take this decision, or should wait until we've come back with our final thoughts. But I'll come to, I've got Councillor Harrison, then I've got Councillor Campbell, and then it looks like I've got Councillor Driver.
Yeah, thank you, Jim. I'll second Councillor Driver's proposal that that document comes in, because part of our remit is to look at possible ways out of this mess. And if this document represents a way out of this mess, it may do, it may not, I don't know. But we won't know that until we see it. I think it's within our remit to look at it. Having sat in the Chair of Scrutiny for quite a few years, I am confused as to why it was referred to the Chair of Scrutiny in the first place. It should have been referred to anybody, it should have been referred to yourself, Chairman, to make a decision of whether to come here or not. But that's another. I'm also confused. I don't think decisions on this are time limited, so yes, it would be nice to get it over with and have another meeting before Christmas, but it's not essential, because I don't think there's any time limits in the document that we're talking about coming to us to have a look at. So I don't think the time is of the essence. It'd be nice to get it over and done with quickly, but if we can't, we can't. Mr. Patterson said officers were asked to speak to the chair of scrutiny. By who?
By a cabinet member.
Yeah, thank you, Chair. I do like pre-decision scrutiny. I mean, I've been advocating for some time, much to the chagrin of most of the officers who can see enormous amounts of work associated with it. I think it's a practice that should be adopted. In essence, that members therefore become more active and more involved in the decision-making process, not being spoon-fed decisions that have already been made. Ultimately, of course, maybe this decision will be taken by the Cabinet, but it'll be taken, hopefully, with the advice and information that we can supply that Cabinet to fully inform them. They can then not argue that they weren't fully informed if the decision is deemed to go wrong afterwards. However, this report or renegotiation, whatever it may be, I am concerned that we're not going to get with it the legal advice that backs it up.
Indeed, indeed, yes.
Because it's all very well us looking at something that maybe or maybe not, and I'm certainly not party to any information about this that the developer has put forward. I want to know on legal grounds we stand and a way forward for us, a plan B. This is what's always been lacking, a plan B. That legal advice, that legal information may inform us and colour our judgment as how we should respond and react to if there is a new deal on the table. That's what's vitally important. Now, I don't want us to consider, put our views forward without us receiving that fulsome, independent of all parties legal advice.
Absolutely.
That's absolutely essential that it goes with it.
Thank you, Chairman. If I can respond to that. Well, the legal advice we will obtain won't be independent. It will be advice for us. I mean, it will be for the council, entirely for the council's benefit. We'll be the client, and the duties will be owed solely to us and not to the developer. We have instructed Pinsent Masons, who are leading construction lawyers. In fact, we have asked them to do two things, because I'm conscious, of course, that you asked me to, you made a recommendation that the Cabinet Leader would give authority for us to obtain legal advice, and that authority was given straight away. We have asked Pinsent Masons to advise on what you specifically requested for, which was the ability of the council to terminate the agreement at this stage, and that advice is now being sought. We have also asked Pinsent Masons, because we need this in any event for the Cabinet to take a view. It's part of the package of documentation and information they need to make a decision. What a risk analysis of the proposed agreement. So again, we want to be able to go forward with members with the financial due diligence, with a legal risk analysis, with recommendations of overview and scrutiny, which will now happen if you look at it, I have to say, because you make recommendations to overview and scrutiny. And then it's for the Cabinet to make a decision based on all of those factors. Thank you.
Can I just say, Chair, that I think it is timeless in the sense that I don't believe it to be coincidental that new offers are coming forward the closer we get to February 2014.
Okay, Councillor Drummond, then I've got Councillor Martin.
Yeah, just a quick couple of points. I mean, I think Councillor Campbell is absolutely right, and we have had this discussion before, but it does seem to me that there is an effort to get something under the radar before we get the legal advice that we've been asking for a long time, and we have certainly been aware of that, and I hope that it's not true that things are going to be sneaked in the back door before anything else can be done. But moving on, I think the other important issue is it's not about the convenience of Cabinet or the convenience of overview and scrutiny panel about the seeing of these documents. I think it's all about the public interest and the people in Ramsgate who have been led a merry dance by these developers for 10 years. And if there are documents that do exist, those documents should be discussed and made available to the people of Ramsgate. And I think they're the people who have been let down badly by what's gone on for the past 10 years. And any scrutiny that we can have in public of these documents, I think, is very, very important indeed, so that the people of Ramsgate, and it's okay the legal officer smiling and pulling faces, It's very inappropriate when we're talking about.
I don't think I was smirking, but I was recognising some familiar refrains, Councillor Driver.
Well, it's all right. It's on film.
But would you accept then that the legal advice which you will be privy to will remain confidential? That's what I'm particularly interested in. The decision on opening up the documents will in the end be a decision that will be taken by members, and that's in fact always been the case. It's not an officer decision, it's an officer recommendation. We never go into private session and we never exclude the press and public unless you, the members, have voted for it, and that will always be the case. There isn't any other way of doing it, as you know. But of course you will be privy to confidential legal advice, and I would be very concerned for that legal advice to be in the public domain. So I would welcome your assurance that if you receive confidential legal advice, we can rely on you keeping it confidential.
And I'm sure you'll be seeking similar assurances from everyone else who sees it, rather than picking on me.
Yes, but I haven't published a front page of the Pink Report on a website.
Which you took no further action on, and which I'd do again in similar circumstances, as I explained. That doesn't necessarily mean I'll do it again. I choose what the public interest is on a case-by-case basis.
Right, okay. Councillor Martin.
Thank you, Chair. I'm finding it actually that I think this meeting is descending into some kind of farce at the moment.
It is.
What are we trying to get out of this at the moment? I'm summarising 3 elements of the discussions so far. We've talked about the due diligence, and in general terms, I think it's fair to say that on one side we have the council relying on solicitors and banks for a large element of the due diligence that has taken place, which in my experience in corporate banking is not an unreasonable position to be in. At the same time, we have a lot of speculation, some of which I think is true, some of which I'm not sure whether it's true or not, about cross-shareholdings and stakes within some of those parties, which may or may not be true. I don't know. Either way, I think that places some of the information that we're getting in doubt in terms of the public's mind. I think the public at the back would be quite reasonable to say, are we now comforted? Are we sure? Are we really confident in the due diligence that has gone before? And I'll keep that as an open statement. I think I probably know what the answer is, and I'm not sure whether I'm much further on. I mean, I'm used to in my professional life relying on the evidence and the assurance of solicitors and banks, but one has to have the confidence that there are no conflicts of interest within those assurances. On the second question that we've talked about, which is the decision-making process, I just find it slightly extraordinary that the administration, which dismissed the concerns that scrutiny raised when it didn't suit them, when they wanted to push through this, the last change to that agreement, we were called all sorts of things. I know that there's a cabinet member here that said he was highly disappointed in the attitude taken of the people that raised questions about that agreement on scrutiny, and I find it extraordinary that the volte-face that has now taken place, and now with that scrutiny is now the font of all knowledge and assurance. And the final point, and probably the most important point, was actually the point that Councillor Campbell made. If I was to make a decision about any amendment to this agreement, I would certainly not take that as a question or a decision to be made in isolation. I would want to know what our other options are, and that is completely saying I want to know the legal advice in terms of where we stand with this agreement, because no decision is valid without that information, in my view.
Well, I agree totally with that comment. I think our next meeting, as we had briefly discussed at our last meeting and a rough idea of what we were looking to do, the aim I thought was for the next meeting to be that legal advice, and that was what we were going to look at next. That was going to be our next thing, and from there, once we had that position, we would then have the opportunity to look at future options once we knew exactly what was going on. It is still my belief that our next meeting should be that legal advice, and that until we've had that, other things cannot be considered properly and should not be considered until we've had it. At this point, I think I know we've got a motion that's been proposed and seconded, but I don't think we've got any other questions. So if we can refer to that, I don't know what the process is in terms of whether that vote goes through, whether we have to hold an extraordinary meeting, whether it's still a chairman's decision, or I don't know what the process is. I don't know if you can enlighten us on what happens next.
So the recommendation is that it comes here as opposed to going.
It hasn't been voted, but that's the current.
Yeah, sorry, Councillor Driver, that was.
It was, yeah, to come here.
And that's been seconded. Well, if you vote that, we'll bring it here. If you can agree.
Yeah, I think there's a degree of unanimity here amongst our members that vitally important papers that we need to see is the legal position that we actually stand in. And until we've seen that, any other papers that may or may not be available shouldn't be seen by us, because we would not be able to evaluate them, because we wouldn't know if the legal position that we currently stand in. So I think, if I'm not incorrect, that your initial proposition was for some alteration or perceived alteration to a contract be presented to us here. Now, yes, I want to see it, but I don't want to see it until, if it exists, then I'm not aware that it does, but if it does, but I don't want to see it until I'm fully apprised of the legal position that we currently stand from this independent, or this legal advice, so that we can see the rounded picture, the full picture, look at it holistically, rather than just seek to make a judgment on some notional change to the development agreement that may or may not be on the table, without looking first at other options or the legal position where we currently stand. So until that legal advice is available, I do not want to see this committee looking at any perceived change to the development agreement.
Councillor Driver, in that response to that comment, and that is my view as well, do you want to withdraw your recommendation until after that meeting? I mean, my current plan, obviously this is out to members and we won't decide, but my current plan is that our next meeting will be this legal advice, and maybe at that meeting, once that advice has been gained, we could then maybe look at this motion again. Is that?
I think my problem is, and I've not seen the document that people are talking about, but obviously it's circulating. My problem is that it's entirely possible, if there is a document circulating which suggests that changes can be made to the development agreement, that those changes could be made and implemented by Cabinet before we get the legal advice. And I think we need reassurances that that document will not be acted on by anyone until we've looked at the legal position. It's got to be so, because with all due respect, you know, the Cabinet may well be honourable people, but equally they may be dishonourable people. Who can tell? And it may well be that something does go under the radar. So I think number one, we need assurances that no action will be taken on these ideas that have been circulated. Number two, it may be serendipitous, but would it be possible to get the legal advice and to get the document together at the same time? I mean, obviously it sounds from what Mr. Patterson has said that the external lawyers are drafting the advice now, and he named the company who's working on it. If they can bring forward their advice over the next few days, or if indeed they can send one of their lawyers to talk to us, so we can look at the two things simultaneously, because I do believe speed is of the essence. And again, I reiterate my position that now, sorry, if you could please be quiet when I'm trying to talk. It would be helpful, as well as I've said, that now the genie's out of the bottle, there's going to be all sorts of speculation going on, as there already is about Victoria Pavilion, about how developments are going to be happening in Ramsgate, because I'm not going to keep quiet about this so-called document. I'm going to be blogging on it, and already I have done. I think there is a responsibility on the council to get the documents discussed right now, as quickly as we can, including the legal advice. And for goodness sake, we asked for that legal advice about 8 weeks ago.
Sorry, I will go to pass in a second if you want to follow up. We asked for legal advice, but it was always a view that this meeting would take place first, because this was the time with the chief exec, and then if we would the update on legal advice, which we have been, and that the legal advice would be our next meeting. That was always our plan as a group. So we didn't make any demands on the time of that advice or when it had to be granted.
Well, we didn't know there was a document.
Well, we still don't. I mean, I have not seen this document. I haven't had anyone tell me this document exists. The only thing I've got is these rumours floating around the ether.
Well,
I hate rumours.
the legal officer has said it does exist, and it went to Cabinet.
I'm happy to answer, but as is ordinary business, officers will work up draft Cabinet reports in consultation with Cabinet through various different processes, typically starting with conversations with the portfolio holder, and then as the document progresses to a proper draft, we have a Cabinet agenda conference where we consider it with full Cabinet and get all Cabinet's comments on it. At that time, the document is still a draft. It has no standing within the council. It is not usually available for any wider distribution because it can change materially. It may actually never see the light of day. It can be withdrawn. It can be deleted. It's actually part of the working processes by which we develop policy documents and documents that support the implementation of those policies. At the moment, there is a document in draft that relates to this particular development and that actually makes representations to Cabinet about the options and looks at some choices around the changes to the development agreement. As it stands at the moment, it is very much a working draft. There has been no decisions about which elements of it should stay in the final report and which parts should be deleted, or if in fact the report should be aired at any particular Cabinet. It isn't on the Cabinet agenda for the 14th of November. It was suggested that it could be something that OSP, either the committee or this working group, could consider as part of the pre-decision scrutiny, and that's where we're at now.
Can I quickly come back on this? I don't mean to labour the point. Very quickly, I've got an answer. The Constitution says that the Overview and Scrutiny Panel and its working groups can see any document in the possession of the Cabinet. This document is clearly in the possession of the Cabinet, so why don't you circulate the document to all of us? We don't need to meet, we can look at it, and depending on what we think of the document, we can then contact you as chair and say, well, let's have a meeting to discuss it, or let's hold it back until we have the legal advice. That is the constitutional position, and I'm happy to amend my motion accordingly, just to say that the draft document is made available to members of this committee. We can look at it at our leisure. If we think there's urgent action that needs taking, we can approach yourself as the chairman. If we don't, we can hold it till the appropriate time. But constitutionally, we can see it, and I believe that this committee would be letting down the people of Ramsgate if we didn't exercise our constitutional rights to ask for it to be circulated within the next day or so. So I'm happy to change my motion if I can get a seconder for having it circulated.
Okay. I'm going to let Harvey respond, and then I've got Councillor Binks and Councillor Harrison.
As the Chief Executive explained, this is a draft document. It's not in the possession of the Cabinet. The Cabinet will be in the possession of a final document in due course, and that will be publicised on an agenda. There will be public notification given of that, and it will be considered at a meeting.
Thank you, Chair.
Point of order. Can we have the Constitution brought and let's have a look now what it actually says? My understanding is the Constitution says any document, and that does include a draft document. So if we're going to start being pedantic, if I'm wrong, I'll apologise, but let's have the Constitution made available now and let's see what it actually says rather than what Ian Driver or Mr Patterson says.
At this point, before we come on to this motion, because this could, you're right, it's descending into farce at a level.
It's not.
This is, my personal view as chair, this is a draft document. I do not think we should be demanding it circulated in the next couple of days. I think once it has been presented to a member of the Cabinet, that would be the right time for us to see it. I certainly don't think, unless a cabinet member was here tonight speaking on 24/1 saying, I would like you to look at this, that we should be seeing it before they should. It is not currently on the agenda for a cabinet meeting. Once this report has been given to a cabinet member, then yes, I think we are in a position to say we should be looking at it. And that is, I think, where the cabinet member would get the report and we would give possible recommendations before the cabinet meeting. That at least is the right process. And we can obviously discuss whether it's the right thing to do, but that, I think, is the process. I certainly do not think, and I don't want to draw into any, but I don't think other members in this panel agree that we should be seeing this before it is at least given to a cabinet member. I'm going to go, who was next, sorry? I'm going to go to Councillor Binks. We obviously separated a little bit. Councillor Binks.
I share the concerns that Councillor Driver has about a speedy decision being made without anybody seeing it. However, I'm reassured by the Chief Exec, by Mr Patterson, by other members of the committee who clearly have seen this document, which I haven't seen at all. Some of them haven't, but some have at least know possibly more about its contents. But the thing is, what I was trying to say is that I agree totally with Councillor Campbell that all the time we don't know the legal view. I think it would be pointless to see this document, which may or may not be worked up into a proper report at some point. At the moment, this is presumably on somebody's desk in draft version and is nothing more. It may get binned, it may be completely changed, but all the time we haven't got any legal opinion here on what the alternative is. I see very little point, much as I share your concerns, I see very little point in demanding to see an unfinished report which may or may not see light of day until we have a view of what the real view, which is that we need a legal opinion first, because then we can look at something else and say, well, okay, we've heard the legal opinion, but maybe this is an alternative. But until we've heard that, we're guessing, we're in the dark. And I think that is the most important thing. So whilst I do share your concerns, I am reassured by the fact that so many people, many of them representing the Cabinet, seem to be perfectly happy that this will not go ahead as a quick decision, which I would think would be in the spirit of the whole committee set up here. And therefore, I completely agree with Councillor Campbell that we should first have legal opinion before we start looking at any reports, half-finished reports, that may or may not be presented to Cabinet.
Councillor Campbell.
Yeah, just a brief point on this. I mean, if a draft document is actually given to us prior to it being verified by Cabinet as being an acceptable document, it gives it credibility and authority that it doesn't deserve. That's the point. It then gives it weight, it gives it legs, which it may not deserve and may not warrant and may not ever get. So we must have the legal advice. Then as soon as it's presented to Cabinet, goes on a Cabinet agenda, prior to it being determined at Cabinet, we should call it into scrutiny and it's determined and looked at here in the light of the legal advice as to where we stand with this development. And that's what we've always wanted.
That's what we wanted.
And Chairman, on the constitutional point, Councillor Driver is right in how he presents it. Any document that's in the possession of the Cabinet in relation to a matter which you were scrutinising and reviewing as a scrutiny subcommittee is a document you're entitled to, but this is not a document that's in the possession of the Cabinet. This is a draft document which the officers are working on. There is a separate argument. This is a draft document about potential revisions to the current agreement, which in a very real sense isn't before you in the first place. So I do think there's no question of you having a. I don't think it's appropriate for you to see it, but I actually have to say I don't think you've got an entitlement to see it either. Thank you.
Right, if I can just work out where we are. Sorry. Sorry, Councillor Harrison.
Do you keep a list of when people? It's generally quite an idea I've found over the years. In view of what Councillor Driver said about putting on this blog site, I'm going to withdraw my second. Because I don't think, even if it's a draft and it goes on the blog site, it will automatically, by analogy, become fact. Because people see things and they don't bother to look beyond what it says. They see the headline, that becomes a fact. So I'm going to withdraw my second into the proposal I still think you need to see the legal advice. At some point in the future, we need to see the document that I referred to. But I think that not now that perhaps is not the time. I would take issue with Mr. Patterson about who's in possession of what. It's not in possession of the Cabinet, it's in possession of the Council. And again, there's a scrutiny subcommittee with the right to see documents that are in possession of the Council rather than the Cabinet. But we could argue that point for months.
Well, rather than run the meeting for months. Unless anyone's got any other further questions for the Chief Executive. No, I want to say thank you very much for coming tonight. I hope members have got answers that you might not be always happy with, but at least here to answer that's always very grateful, especially the time you've had to give up. I don't think there's any other points. I think at this... Sorry?
Chair, have we agreed that we are going to have legal advice in some form at the next meeting?
Yeah. So my proposal is that our next meeting will be the meeting where we are given that independent legal advice. And obviously the date for that meeting will be dependent on I don't know if it's going to enlighten us on any progress, but that will be the dictation. And unless anyone's got anything else, that will be the plan.
Well, I'll be chasing for that advice to be received as soon as possible because, as I said, I've asked for 2 pieces of advice and I require the other piece of advice to progress the document of which we have been speaking, as well as what you're interested in, which is what can we do now under the present arrangements.
Okay, so in that case, our next meeting will be to look at this independent advice. We can't set a date at the moment because we have to wait for that advice to come in. So I'm sure in the near future, Mr. Hungerson will come out with possible dates for a meeting. And the agenda item will be to look at the independent advice given to us. Unless members have got anything else, I think that's an end to the meeting. Thank you.